training, that is a BT training which is prescribed there, they will be deemed to the qualification prescribed under subsection 1.3.1. And for these teachers, these four categories mentioned in paragraph 1, 3, 4, and there's a fifth category which says that those teachers whose recruitment started prior to the coming into force of the Act and were recruited under the regulations of 2001, they also will not be required to have the qualifications mentioned in para 1. So my respectful submission before your lordships is that the proviso says qualifications laid down in subsection 1, and the qualifications that have been laid down in subsection 1 for us who were working for a very long time is covered either under para 4.
Second, very well, 17 to 24.
Yes, it's relevant part only.
We have not. It's not in your review petition.
It's not. It's quoted. Is it quoted?
No. If it is not there, don't expect us to pick it up from anywhere.
I have
should have annexed it to the review petition. Or you should have all come with a compilation of the statutory provisions and the notifications so that we don't have to struggle to find it out.
P1.31. No, point 1 and it.
You have made your point that this cannot be given retrospective effect.
And Malats will also brought into effect, Malats.
We'll note it.
The NCT notification, page 49 of Malats will
This cannot be a hearing of the entire matter, so let us give chance to every council. Right? Mr. Banerjee's submission, we are reporting.
So, Malats, our submission is it was brought into effect, Malats, in short.
Very well, this is your point.
Malats, 1, and it was brought into effect by that 23/8/2010, which has been interpreted by this honorable court saying that it's prospective in application. The exact, Malats, that is also, I'm just mentioning that Arvind Kumar Yadav,
Give the citation.
Anand Kumar Yadav, Malats, that citation is 2018-13 Supreme Court cases 560, para 27 and para 28, please.
27 and
28.
Very well.
Which, that's the NCT notification which brings into effect this qualification. And that says it's prospective.
Would I assist your lordships? Can I?
Mr. Jha, please wait for your turn.
Yes, ma'am.
Please wait for your turn. You're not here physically. You're joining through the virtual mode.
I'm grateful.
For the right of pre-audience. And there are senior counsel who are enrolled before you in the bar.
I'm grateful, my lord. I'm grateful.
Yes, Mr. Dwivedi, you're the senior most?
Yes. No, I
senior most?
Seniority.
No, we'll go by seniority then. We'll go by seniority as per enrollment.
Opposing.
We want a review.
Quickly go by section 23 Advocates Act.
Right. The problem is they don't know our seniority.
You don't know your seniority.
We don't know.
You'll have to figure it out.
We'll just take 2 minutes time.
It's 3 minutes, sir. We will.
2 minutes.
I'll excuse myself from.
So a very short point. So just note the point. I'll take
the point.
Just one by one.
Yes.
Bhattacharya, please wait. Let Mr. Dwivedi take 2. Dr. Singh will take.
Right. So kindly have the second proviso, Mulats. Kindly have the second proviso, Mulats.
Mr. R. Dwivedi.
I am appearing for the state of Madhya Pradesh, Mulats. Just bear in mind one fact, not that prior to the enforcement of this act in 2009, and the issuance of the notification under Section 23, one the Academic Authority on 23rd August 10, we had our own set of rules, blood, and an examination also for recruiting the teachers. So everybody has, and the qualifications which are prescribed under 2000 and under Section 23(1) are substantially similar as in our rules prior to 2009. After 2010 in Madhya Pradesh, everybody has a TET. Question is of not extending this to a point of time prior to the emergence of this act itself. So I'm only attempting to draw your lordship's attention to the extension of retrospectivity prior to 2000, this emergence of this act and the notification of 23rd August. Now please see the second proviso.
Yes.
Provided further that every teacher appointed or in position as on 31st March 2015 who does not possess minimum qualifications as laid down under subsection 1. Please mark this expression, as laid down in subsection 1. Now this notification, therefore, this takes us back to 23.1. And 23.1, the notification has come on 23rd August 2010. So therefore, it is only the retrospectivity can be only to the point when the qualification was prescribed under 2010. It cannot extend to 1998 and 1995 when the teachers were recruited. So if after 2010, there is somebody lacking TET or other qualification, I'm assuming that TET is also qualification. That's what your lordships have observed. I'm not for the moment questioning that as far as I'm concerned. So assuming TET is there,
Well, thank you.
the TET came in 2010. Before that, we were having our own examinations, and there was no TET.
Where is my... Sorry.
So therefore,
Just tell you what I have noted from your petition, State of Madhya Pradesh.
yes, ma'am.
Education is a state subject. There existed state law prior to the coming to force of the
Yes.
RT Act. RT Act does not automatically override the state law. This is one point. Court had no occasion to examine the interplay of RT Act with state laws. Interpretation of court does not align with the statute and rules thereunder, which never intended to apply TET to in-service teachers. Of RT 2017 highlights that infrastructure was sought to strengthen the training for the untrained teachers. The intention behind including proviso can never be to apply to in-service teachers. Over 70,000
So
teachers.
your lordships have rightly noted the submissions from them, but I am not saying that after 2009 our state act will continue. I'm not saying that. I'm not saying so. Please.
For those teachers who have been in service for more than 2 decades, 3 decades, we have provided a relaxation for them depending upon their age. But those who are 55 plus, they need not. But we have a great size of one.
With great deference, my lord, second proviso does not require extend its application to those recruited earlier.
What do you mean by 31st March 2015, sir?
Lord, that has to be restricted to the notification because it says as provided in subsection 1.
Every teacher notification under 21 prescribes the qualifications which every teacher has to possess. Second proviso extends the time period that if you have not acquired the qualification within first 5 years, we are extending it for another 2 years. Otherwise, this proviso does not bear any meaning.
Because if it is not extended earlier to this point of time, 23rd August 10, it will be manifestly arbitrary. But
We'll consider.
kindly just examine, Lord, if today we are required to pass the Bar Council examination after 30 years.
This argument was raised, Mr. Dwivedi. We had the occasion to
This
consider.
act does not purport to repeal our state acts and rules retrospectively.
We'll consider. We are not saying we'll not consider. We'll consider.
Now, it's my...
Dr. Singh, you are for whom?
I am for this entire batch of 2001, 2002, 2003.
No, in the
Individuals.
what is the name of your
301.3. 300 point?
301.30.
3.1 is 301.30.
Can you give the name of the party?
Amit Kumar Singh. That is... will you stop a commentary? 301.30. Amit Kumar Singh. I only have 4 dates to give your lordship. Only 4.
Very well. Amit Kumar Singh.
Yes. Your lordship, keep this compilation on the side. My 4 dates are this first. There was, just 4 days, lordship will note. There were 3rd September 01 regulations.
3rd September?
01. That is well as 25 years ago.
Yes.
In this compilation at page 23 are the extant regulations on that date. I was clearly qualified under them. Please give it to my lords. Page 23. Only 4 dates and 4 documents. Well, I won't take long. I need not go into the merits of it. Just glance at it as to whether this is 2001 September. That table was. Don't go into the nitty-gritty of it, but they clearly qualified under that. This is my compilation.
You said 3rd September 2001. This is not there in your compilation? Okay. Second, very well, 17 to 24.
Yes, it's relevant part only I'm showing one is 22 at 23.
22 at 23.
Number 2.
Yes.
That is number 2. Of course, in between now comes on 1st April 2010, the Act, the RTE Act. That date is 1/4/2010.
Yes.
On 23rd of August 2010,
Yes.
a notification is issued requiring the TET. Right, fellas?
Yes.
But it has a significant exemption because they know that there are 50 teachers like this in the rural areas who don't have this qualification, who have the other one. That is relevant at 31 of this compilation.
30?
Yeah, it starts at 29. Joshua may ignore the rest.
31.
At 31, that exemption is consciously given to protect people like me. Teachers appointed before the date of this notification, of course, I'm in the hoary past. Even immediately before this is 2010. The following categories of teachers appointed from classes 1 to 8 prior to the date of this notification need not acquire the minimum qualification specified. Then, brothers, a particular category is A. If appointed on or after, then there's a proviso. We're not concerned with that. The third is that this exemption at page 31 is reaffirmed and reiterated at 34. That's my third point. 29th July 2011 Lordship is reached now. That is 1 year after the RT Act.
Yes.
Justice Barmore has got 34. On this date, the relevant part of this is at 34 starting, 35 is the relevant part.
Yes.
Teachers are 5A. Teachers appointed after the date of this notification in certain cases, where an appropriate government or local authority or a school has issued an advertisement to initiate the process of appointment of teachers prior to the date of this notification. Such appointment may be made in accordance with the NCTE regulations of 2001, which I showed to your lordships. Conscious exemption because they didn't want to penalize people who had done to the best of their ability in the hoary past something, which was then the valid thing. Then, Malas, comes the amendment to the Act as the 4th document or the 4th point. That is at 38. 38. That is the NCTE Act amended. 38 at 47 is the amendment of 12 capital A. 12 capital A. This is Malas WEF 16/2012. WEF 16/2012. Not sure you got 12A? Justice Banwar has got 12A. At 47, what is 38 at 47? 38 at 47.
Yes.
Now, I am interested in the proviso, but your lordship may read the whole. Power of the council to determine minimum standards of education. For the purpose of maintaining standards of education, the council may by regulations determine the qualification of persons who will be appointed as teachers in any pre-primary, primary, upper primary, secondary, senior so-and-so, intermediate, by whatever name called, run, aided or recognized by central government. Provided that nothing in this section shall adversely affect the continuance of any person recruited in any pre-primary, primary, upper primary, senior, secondary, intermediate, or the colleges under any rule made by the central government, state government, local authority, other authority, immediately before the commencement of the so-and-so Amendment Act of 2011. Such qualification as may be specified. Further, the minimum qualification referred to, etc. These are conscious statutory or delegated legislation exceptions.
No, read further, provided further.
Yes, provided further that the minimum qualified teacher referred to of the first proviso shall be acquired within the period specified in this act or under the right to free act, etc. Correct?
You will have to acquire it.
No, but now, these are people who have been there for 50 years.
Maybe the statutory provision is that you have to acquire it. See, the problem that is arising over here, Dr. Singhvi, is precisely this.
Before this amendment.
This proviso says that even the teachers who've been appointed prior in date
Yes.
will have to get this additional
That may not be the right interpretation. May I explain why?
See, we have looked at it and my brother has explained it in detail.
So therefore, I am
Writing it, looking at the act from the perspective of the child. We are saying higher education qualifications of the teachers is required because we must get the best teachers.
So let's
See, unless until you get good quality education, how will the child improve?
So my answer is this.
You have to have good quality
I am
teachers.
requesting my lords to interpret it as a very strong alternative interpretation. This one which your lordship asked me to read is a proviso which will apply to those appointed after the act but before the amendment.
No, that is not so.
Before the amendment. No, because the amendment says so. That's the contention. Please see. This is brought by an amendment. It is not brought by the act.
Can I have 5 minutes? 5 minutes.
What Dr. Singh said, but after.
Just 5 minutes. Well, kindly, who are you for? I am for Milord. Point 57, Jyoti Singh. So, Milord, if your lordship had those 4 dates again, they have reference to papers. Jyoti Singh? Yes. So, Milord, the first relevant date is 1/4/2010. That's the commencement of the Act. The Act of 2009 came into effect on 1/4/10. So prior to 2010, there was no real problem. On 1/4/2010, my lord, there was no TET requirement. The requirement came, my lord, on 23rd August 2010. And then, my lord, is the last date, which is, I think, 23rd of August 2017, when the second proviso, my lord, was added, which takes us back to being in position in 2015. That's, my lord, the conspectus. That's the conspectus. Now, my lord, if your lordship will be pleased to see section 23 and the notification of August 2010. Just see 23 once again. Yes. Any person's qualification is laid down by an authority authorized by the government by notification shall be eligible for appointment. So this is not prospective. Those who are going to be appointed. Then the lordship sees beyond the first proviso. Provided a teacher who at the commencement of this act, commencement of the act is 1/4. The commencement is not August. Whoever, blood, at the commencement of the act, that is a person, blood, who's already there. So there are 2 different blood groups. Under those who are going to be appointed henceforth, and this proviso is those who are already, blood, in place. Those who are, I'm reading, blood, that way, those who are teachers who are at the commencement of this act, that is, blood, on 1/4, do not possess minimum qualifications. Under 1 shall acquire. The submission is like us who were there as on 1/4. We possessed the qualification under 23(1) because there was no August. There was no TET. So to say, my lord, that we will be given a grace is wrong because the issue arose in August. So on first principles, those who were in place by virtue of, my lord, this proviso would only be required to fulfill 23(1), and 23(1) on 1/4/10 did not have TET. That's one part. Now, my lord, your lordship may have a look at the notification of August. My lord, your lordship might have it in Mr. Singhvi's compilation.
Mr. Roti has not looked at second proviso. The whole case is on second proviso, not the first proviso.
Second proviso comes in 17. I'll come to that, my lord. Please bear with me.
First point I'm making is, this proviso does not apply to me.
Proviso, not on the first.
I'm developing the first, then I will go to the notification, then I'll go. Obviously, my lord, if you just read the second, then obviously if you look at it that way, then everything is gone over. What I'm trying to say is, my lord, I was not requiring any grace as on 1/4/2010. In short, I didn't require a grace. I was very much in place with the requirement of relevant qualifications as on, my lord, 1st April 2010, the first submission, without grace. Now, my lord,
1st April 2010,
my lord,
the qualifications had not been prescribed.
correct.
It came into existence
August.
on 23rd August 2010.
Right.
So therefore, what the first proviso ordains is this. If you are a teacher on 1st April 2010,
Yeah.
you are given 5 years time to acquire the qualification. From which date 5 years will count? It cannot count from 1st of April 2010 because the qualifications had not been prescribed.
Correct.
It will count from the date the qualification is prescribed. That is 23rd August 2010. You have a window of 5 years. 2015, if you don't qualify,
I understand, Lord.
2000.
Yes, yes.
See, that is why it is again made
My lord,
effective with retrospective effect.
I submit.
You are given 2 years time.
I
5 plus 2.
am only saying, my lord, in fact, the first proviso talks about commencement of the act.
Mr. Roti, my brother has been very benevolent in giving you some extra time. I was telling him, let the statute operate as it is, and we had a long
All
discussion
right.
on this.
So one more argument. One more argument.
He's been very, very benevolent.
Now, one more argument, my lord, which is based on what your lordships gave me in the order. To you. Let me read the order first, my lord, and then make the submission. Kindly turn to para 168. 168 of your lordship judgment.
Paragraph 168.
Yes. NCT 168. The argument is this, my lord. In other words, that the requirement of TET is only for those who were appointed post-August 2010. In that light, we were exempt in 2010. My lords will remember, we were exempt under 2010. Can I just show that and then read 168? 168 is completely in my favor. May I read 160?
Read it. Just answer one question.
Yeah.
The requirement gets incorporated on 1st August 2010.
Sorry?
The requirement gets incorporated.
Yes,
first.
absolutely right.
So there can be no recruitment after 1st August 2010.
Without that.
If your submission is accepted, then the second proviso will have no relevance. It should never have been there.
So what I am
Therefore, Mr. Roki, you're missing the point. The point of what is the significance of second
You
proviso?
know, second proviso does not specifically say that the exemption granted in 2010 is gone.
Who are in position on 31st March?
Of course.
They will have to acquire it.
Mr. Roshi,
So by
the teachers have to upgrade their skills.
Achha,
They
yes.
have the best standards for the
I
examine it from the
I've
source
seen,
point.
Lord, I've seen. I am seeing which way the wind is blowing. So I won't put it another way. I just want to read 168.
Okay.
This is not in my favor. That's why I'm reading it. Para 168. NCT's notification reinforces this requirement by stating that teachers working in unaided schools or those in position as on 31st March 15, like me, my lord,
That is the relevant.
must qualify TET. Now, next para is important. The language of both the RT and the notification leaves no room for ambiguity that even those who are appointed prior to RT, like me, if not qualified, must not be TET against me within the grace. Now, look at the next line. Only those appointed prior to so-and-so in accordance with those applicable rules or covered by specific exemptions, this is in the notification of 2010, are exempt.
Exempted, but thereafter 17 does not grant you that exemption.
Lord, if you are
This is the difficulty.
you are exempted and then you take what you give by the left hand, you take it away by the right.
Yes.
What happens?
Let's just add one line.
Yes, yes.
Go back. You had your fill.
Mr. Gupta, you were there?
You had your fill in the previous round. How many days you heard you?
May I remind the Lordship?
5 days.
He should not be stopped, my lord.
No, but Mr. Gupta will hear you because there are other people.
If your lordship is going by seniority, my lord, then Mr. Bikash Bhattacharya should be heard first.
Then-
Then me, then my lord.
Very well. We'll go by seniority.
I would like myself confined specifically to the question of law 23 proviso, second proviso.
Second proviso, yes.
May I read it? Lord?
Mr. Bhattacharya, who fought whom?
1931 and 2325.
Now just give the
19
first party's name.
বিধান কুমার মন্ডল
Bidhan Mondol.
আর আমাদের পাসপোর্ট
Bidhan Kumar Mondol. Right.
শ্যামলী হালদার
And Shamali Haldar.
0.31 শ্যামলী হালদার আর সোনালী চৌধুরী and forensic
Bidhan Kumar Mondol. These are separate review petitions.
yes madam 3
Shamali and the last one,
সোনালী চৌধুরী
Sonali. Very good. Yes, Mr. Bhattacharya.
That section 23 should be read in its entirety.
Right.
Yes. Now, the first is not the Act desires that there should be a prescribed qualification by competent authority. And then say that any person possessing such minimum qualifications as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as teacher. This is the prospective in operation. Now, second is where state does not have any adequate infrastructure, they will be given 5 years time. That second, provided the first proviso. A teacher who at the commencement of this act does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualifications within a period of 5 years. And then second proviso, provided further, this is important, Lord, we are governed by this, that every teacher appointed or in position as on 31st March 2015 who does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualifications within a period of 4 years from the date of commencement of the Right to Children Education Act. Now, our appointment was, my lord, at a point of time when, my lord, the academic qualification was, my lord, determined by the NCTE. And my lord, will kindly turn to, my lord, the
regulation
in the matter of, my lord, Anjuman Bidhan. Will kindly turn to, my lord, page 155.
What is that? What is that 155?
155 is the NCTE, my lord, regulation, notification, dated 23rd of August.
23rd August 2010.
Yes.
Very good. Yes.
Now, my lord, here, my lord, we'll find, my lord, details are given, then kindly come to, my lord, at page 157.
You just refer to the regulation number?
Yes.
Because we are looking at this compilation.
The regulation 4. Regulation 4 of,
Regulation 4.
yes, of 23rd August 2010 regulation. Notifications.
2010 notification.
The teacher appointed before the date of this notification.
Yes.
Is that the marginal note?
Yes. Teacher appointed before the date of this
This notification. Yes.
The following categories of teachers appointed to class 1 to 8 prior to date of this notification need not acquire the minimum qualifications specified in para 1 above.
Right.
That a teacher appointed on or after 3rd of September 2001, that is the date on which NCT determination so-and-so regulation 2001, as amended from time to time to force in accordance with the regulation. And my lord, we are all governed by these. Then, my lord, TET was not at all, my lord, a qualification necessary for the purpose of recruitment teacher, but we had, my lord, different training, not TET. Can my lord kindly turn to, provided that a teacher of class 1 to 5 possessing B.Ed qualification or a teacher possessing B.Ed special, my lord, this is not relevant.
2001 regulation.
Then my lord will kindly take the trouble to turn to page 163.
Good to hear Bengali in court again.
That is the inherent resource. Kindly turn to page 163. That will also clarify the position.
This is what?
29th of July.
29 July 2011.
Yes.
Yes, 29 July 2011.
Yes.
Which clause?
Kindly turn to clause 5. Another para 5.
July 2011. Yes, para 5.
For para 5 of the principal notification, the following shall be substituted, namely, teacher appointed after the date of this notification in certain cases where the appropriate government or local authority or school has issued an advertisement to initiate the process of appointment of teachers. Prior to the date of this notification, such appointments may be made in accordance with the NCT Determination Regulation 2001. Therefore, it's very clear that the NCT had the basic conception in the mind that prior to 2001, the TET qualification was not available, it's not necessary. Then let B. The minimum qualification norms referred to in this notification apply to teachers of language, so and so for different languages. Now, basic thing, Milord, that even in 2011, the NCT found that 2001 regulation appointments did not come within the scope of TET. That is one important thing.
2001 regulation.
If your Lordship kindly comes, 2001 regulation, Lordship will be pleased to find
Page number 142.
137. Turn to page 137.
2001 regulation.
What is that?
That is the 3rd September. সবাই মিলে কথা বললে কোর্স হবে কি করে?
3rd September 2001.
This is the Millard. The qualification regulations may be called National Council for Teachers Education Determination of Minimum Qualifications for Recruitment of Teachers in School Regulations.
So you are referring to which particular regulation?
I can't see that your Lordship will not find date mentioned.
No. Of course, 2001, only after the RTE Act.
Right, so.
So 2001 date was unknown.
What I
It
said,
was unknown.
that's why these notifications will give exemption to the teachers who were appointed prior to the knowledge of TET.
Very good.
And this exemption was considered by your Lordship. Kindly turn to my Lord's own judgment.
Yes.
Para 168.
That has been placed just now by Mr.
Yes, may I just repeat? Kindly, page para 168 is very important.
Page 90.
Page 90. Well, I will read it a little slowly for my benefit. Well, I would rather read 167 to my Lord's reasoning to arrive at 168. Importantly, the first and second proviso to section 23(2) of the RTE Act carve out a transitional obligation for in-service teachers who did not possess the minimum qualifications at the time of commencement of the Act. They were required to acquire such qualification, including passing TET within a prescribed time frame. The second proviso introduced by the RTE Act extended this compliance period by a period of 4 years from the date so-and-so. The express legislative intent was to bring in all service teachers within the ambit of uniform quality standards. Then, NCT's notification also reinforces this requirement by stating that the teachers working in unaided private schools, so those already in position on 31st of March 2015, must qualify the TET with the stipulated period. The language of both RTE and the notification leaves no room for ambiguity that even those teachers appointed prior to RTE, if not qualified, well, this is important, if not qualified, must meet the TET requirement within the grace period. Only those appointed prior to 3rd September 2001 in accordance with the applicable recruitment rules or those covered by specific exceptions were exempted. But this is the finding of the Honorable Court, which will not really supports my cause. But in the direction portion,
This is just noticing the relevant statutory provisions and ultimately 23 subsection 2 second proviso, pins you down.
The second proviso pins me down, I have no quarrel, but that will not empower the...
Because whatever exemption is given under a notification cannot override the statutory provision.
My Lord,
NCT cannot grant an exemption which the legislature is not providing. The will of the people has to be respected, Mr. Bhattacharya.
The deepest of respect, Lord, I just like...
And you are expressing the will of the people
I am.
presently.
Now, I am trying to point out, Lord, that the statute says it depends upon the academic authority. It depends on the academic authority.
We will
The
consider.
academic authority felt it. Academic authority felt it that these people need not go to TET. I can also concede to the extent that if the court feels that they should upgrade their skills, let them do it. But that should not be coterminous with their recruitment. That would be too atrocious.
Very well. Thank you.
But you give the same benefit that is given to the others, that you may not. But you,
I'll just state the two submissions. First of all,
Who are you appearing for now?
Milord, state of Tamil Nadu.
Just written by state
Yes,
Tamil
yes.
Nadu. Very well.
And Milord,
We have been hearing in from the morning
Yes.
adjournments because
Change
there
of
will be a new problem.
Milord, your lordship is not going to adjourn this matter, Milord, so we better be here. Now, Milord, I appear in 14 matters, Milord, but the list is there. I don't have
Very well.
to.
For state of Madras.
First state of Tamil Nadu.
State of Tamil Nadu.
2 points, Milord.
Yes.
By directing compulsory retirement, your lordship has interpreted the second proviso in such a way that it introduces an eligibility condition decades after the person went into service. Now, even though this may be for the benefit of the students, it goes against a very fundamental principle of service law, which also must be applied. That's my first submission. Second, my lord,
may I take leave?
second thing is this, my lord, we have given the facts. 4,49,850 teachers in total in the government in Tamil Nadu. 3,28,701 not qualified under TET. In 2 years' time that your lordship has given us, my lord, it is administratively impossible to repopulate, my lord, the entirety of the service.
Statute gave you 2 years in 2017.
My lord,
We have given 2 years in 2025.
no, my lord, no, my lord.
If your teachers do not equip themselves, Mr. Gupta, we wouldn't expect the state of Tamil Nadu to
My lord, would your lordship, my lord,
come
kindly,
forward on behalf of the teachers.
no.
By now there may be several
my
lakhs
lord,
of
just kindly permit me to end my submission.
Right.
The difficulty is, my lord, if it's administratively impossible to repopulate the service, my lord, then the schools have to be shut down. That's what I'm trying to say, my lord. And my lord, your lordship's held.
What happened in 2017 when this notification came?
It wasn't interpreted to mean what your lordship has now said.
It is
Your lordship has
clear.
interpreted it for the
very
first time.
clear. It is very clear.
It may be, my lord, clear to your lordship, my lord.
Required no interpretation, but the court is forced upon,
However,
interpret a plain and simple statutory provision.
all I'm saying, my lord, is kindly give us at least 4 years' time. Otherwise, administratively, my lord, it is impossible and the schools will have to shut down. My lord, this is in grounds 4 and 5 of my review, my lord.
Oh, yeah, just time.
Yes, my lord.
We'll keep in mind. Lord, yes, Mr. Patel.
I am for the teachers in the state of Jharkhand. We have
Just 1 minute.
Sorry.
What is the cause title of your petition?
cause title is my lord Akhil Jharkhand Prathmik Shiksha Sangh. Akhil Jharkhand Prathmik Shiksha Sangh. It is 301.2.
तो number पे है.
Point 2. We are teachers, my lord.
अच्छा, अखिल झारखंड प्राथमिक शिक्षक संघ झारखंड.
Correct.
You have raised 7 points.
Correct.
Oversight of NCT notification which exempted 3/2010 appointees from writing.
I am starting from
First, court misconstrued RTE Act 17. Intent was never to retrospectively impose TET on teachers appointed prior to 10. Executive clarification dated 3rd August 17 to the effect that teachers appointed prior to 2010 did not acquire this qualification. Rule 9 of RTE amendment rules violated our interpretation has violated rules very well.
Yes, it
Treating
I am not present.
pre-2010, this is what we have called out from your petition.
Correct.
Treating pre-2010 appointees with post-2010 appointees amounts to hostile discrimination, violation of 14. 6. Appointees fulfill the eligibility conditions when they were appointed under the relevant state rules. This is the common submission. And new promotion rules 2025 of the state has granted exemption. So state law will override a central law.
So, my lord, I am not going to argue all that.
So which one will you argue? Tell us out of these 7.
My lord, the point I am essentially placing before your lordships is that your lordship's judgment now, as my learned friend Jaideep just said, your lordships are virtually imposing a new condition of eligibility by a judicial interpretation, which if possibly the executive had done by a service rule, may have been liable to being struck down by your lordships. And realizing this, my lord, one line of the 2010 notification has been probably overlooked or missed. Please see page 42. We are people who were recruited from 91 to...
You are referring to which regulation?
Yes, please see page 4. I'm
No, we are not looking into every petition because there are more than 100 petitions. It's absolutely impossible to have 100 petitions.
31st March 2010 notification prescribing the qualification.
1st March 2010. It's not in this compilation. Do you have a copy?
In your lot at page 41 it is reproduced.
Page 41.
41.
Page 40. Just see paragraph number.
Para 62.
Para 60.
The reference comes from para 61. This is under that heading where acts and notifications where your lordship have done. Now please see para 61. Your lordships have said central government notification dated 31st March 10 appointed NCTE as the academic authority. Then thereafter the 23rd August 2010 laid down minimum qualification. This is what I am reading. Please have the next page, para 4. Teachers appointed before the date of this notification. The following categories of teachers appointed for classes 1 to 7 prior to the date of this notification, we are that class, need not acquire the minimum qualifications specified in para 1 above, and C, a teacher appointed before 3rd September 2001 in accordance with the prevalent recruitment rules.
Right.
Now, this recognizes a very established principle of service jurisprudence which says that your conditions for eligibility for appointment, your lordships have subsequently said promotion will be included in appointment. I have no quarrel with that. Perhaps I may not be able to get promoted till I acquire the TET qualification. But the question is, would my original appointment be also under jeopardy on account of a qualification which is laid almost a decade after or 2 decades after I have come in? And according to me, my lord, the central government has saved us under para 4 subclause C. And once...
Some notification which is prior to the statutory amendment. Statutory amendment has not been challenged. That of 2017.
That is the fresh notification.
Look at para 69 of the judgment.
Correct.
The executive has written a letter.
Correct.
Just turn to para 69.
Yes.
Order, please read it.
I'm reading it.
Yes.
On 3rd August 2017, the Additional Secretary, Ministry of Human Resource Development, Department of School Education and Literacy, issued a letter to the state secretaries demanding them that the last date to acquire minimum qualification is 1st April 2019, and no teacher who did not possess the qualifications under the RTE Act would be permitted to continue. So, Lord, this would have to be read.
My brother has been more than benevolent.
I has been informed as far back as on 17.
I do understand.
Therefore, the executive stand was also this before us, that this qualification is mandatory. It had to be acquired within 2 years of 2017. My brother has said it's not required for people.
I realize, Lord, I was...
Within 5 years, then even till 5 years, you got it in
my submission is...
extension of time.
My submission is that if we are exempted under the basic notification, all subsequent statutory regulations will not come.
But that notification has to yield to the law.
You are not looking at this statutory amendment.
Statutory amendment.
That will relate back to this act itself. It will not cover a person.
Amendment, if it had not had those words, 3rd March or 31st March 2015, we could have interpreted it otherwise. We have put these review petitions only to get assistance from you. How do we interpret the second proviso in a manner different from the one
My reading is
in which we have
my
interpreted?
reading is that if a person is already excluded from this whole new statutory framework, then any subsequent amendment or proviso will not bring him in, my lord. That is all that I'm trying to say.
That's the next in seniority.
I go in.
Mr. Giri.
Very grateful, my lord.
301.8.
What is the name of your client?
Meghraj Singh and others. It starts from page 111.
Just one.
What he says.
Meghraj Singh.
Yes, my lord.
Meghraj Singh.
My lord, altogether 232 petitioners.
Deprivation of livelihood, retrospective application is irrational. Education is a state subject. State laws predate RT. Education is a concurrent subject, not a state subject. Book of notification dated 23rd August 2010 exempted teachers appointed prior to the notification. Proviso to 23(2) provides for acquiring minimum qualifications within 4 years. For teachers appointed prior to coming into force, TET was not a minimum qualification. These are the grounds that
These are the grounds. My lord, they have been argued in one way or the other.
it has been argued.
And therefore, my lord, why should I take up your lordship's time on that?
Right.
But please come to the section.
Yes,
Because this is where your lordship seeks some.
Please, we want assistance on 23.
Yes.
2 second proviso.
Lord, this is something, my lord, which I am advancing before your lordships. Because this is a manner in which if it is read in this manner, probably many of us come out of the net as such. Please come to section 23 once more.
Yes, we are on 23.
I'm exempted.
My lord, this was there right from the beginning. That is from 1/4/2010 onwards. Any person possessing such minimum qualifications as laid down by an academic authority. Academic authority, my lord, is also subsequently defined
As NCT.
as NCT. Authorized by the central government by notification shall be eligible for appointment of a teacher as a teacher. My lord, subsection 2 may not strictly apply, but for the sake of completion, let me just read it. Where a state does not have the adequate institutions offering courses or training in teacher education or teachers possessing minimum qualifications as laid down under subsection 1 are not available in sufficient numbers, the central government may, if it deems necessary by notification, relax the minimum qualifications required for appointment as a teacher for such period not exceeding 5 years as may be specified in the notification. My lord, the second proviso was not there. Probably addition of this bringing in a qualification, my lord, post prescription of the qualification as per a notification dated 23/10/2010 might have been ultra-wise. But your lordships are right. There is a substantive plenary amendment. Provided that a teacher who at the commencement of this act does not possess minimum qualifications as laid down under subsection 1 shall acquire such minimum qualifications within a period of 5 years. Suppose we stop with that. Then also, my lord, all those persons, these 232 persons, like several others, they were all appointed prior to 23/10/2010. They were appointed prior to 1/4/2010. There were many of them are appointed in 2001 and up to 2009. Therefore, my lord, the first proviso also does not hit them in that way.
No, it hit them. They did not realize it. Because they were teachers. It says provided that a teacher,
Yes.
not a person. Person is referred to in 23(1).
Yes.
First proviso does not refer to person.
Yes.
It says provided that a teacher
Yes, my lord.
who at the commencement of this act, that means 1st of April 2010,
Yes.
your client is a teacher
Yes.
and does not possess the minimum qualification under 23(1),
Yes.
shall acquire such qualification within a period of 5 years.
That's right.
So you are a teacher in position on 1st April 10th. You are given 5 years time to qualify.
My lord, the minimum qualifications laid down under subsection 1 is by means of a notification.
Right. So
Insofar as the first proviso
that comes on 23rd August 2010.
that's right.
Right? So 5 years cannot be counted. Not from 1st of April. 5 years will obviously have to be counted from the date of the notification. Correct, my lord. No, you are a teacher. No, my submission is this, my lord. My lord, first proviso therefore says, possesses minimum, sorry.
For me, qualification, the minimum qualification to establish that time.
First proviso therefore says, who at the commencement of this act does not possess minimum, as laid down under subsection 1. Now, who lays down under subsection 1? As per a notification. The notification under subsection 1, which has actually continued to remain from 2010 till date, is a notification dated 23/8/2010. My lord, what your lordships have seen,
The act first April, I'm exempted then it will be and this is could be different solution. And this for people who weren't exempted.
That also covers.
yes, no, my lord.
You're saying that
My lord, the 23/8/2010 notification will have to be read into subsection 1. Because subsection 1 contemplates that there has to be a prescription in terms of a notification. If you read the notification dated 23/8/2010 into subsection 1, section 23(1), then first proviso would also draw sustenance from that.
First proviso may draw sustenance, but the problem is the first proviso uses the expression commencement of this act.
Yes.
Commencement of this act is 1st April 2010,
Yes.
not 1st August 2010.
No.
So therefore, the qualification which is prescribed on 1st April will have to be met by the first proviso. The second proviso is talking about the cutoff date as 31st March 2015.
Can I come to?
Name is this.
I'll come to the
NET qualification has come in. Qualification has come in.
I'll come to the second proviso in a moment, my lord, because I made this submission and my lords felt, and I am also hit by subsection, the first proviso. Both 1, 2. That's right. Therefore, insofar as 1 is concerned, please read the 23/8/2010 notification into subsection 1 and please have a look at the notification. It's not a question of exemption. Prescription comes under the 23/8/2010.
The second proviso is a complete knockout punch.
No,
you don't forget. You're on the background.
Lord, I'll come to the second proviso in a moment.
The second proviso, right?
I'm anyway tottering on the ropes. Therefore, my lord, let me come to the second proviso.
Other council.
I'll just take a minute. I'll just take a minute. I understand, but I'll just take a minute. The notification dated 23/8/2000. This is my submission.
Yes.
Notification dated 23/8/2010 will have to be read into subsection 1. It has to be read into the proviso also. When your lordships read the notification, your lordships will have to, because the prescription contained for minimum qualification in the 23/8/2010, this is where TTE comes about under the 23/8/2010. There is no plenary statute prescription for TTE, nowhere. And then when your lordships come to clause 4, training to be undergone, clause 3, then clause 4, this is also a prescription, not an exemption. The following categories of teachers appointed for classes 1 to 8 prior to the date of this notification need not acquire the minimum qualification specified in para 1 above. And then, my lord, the prescription comes about. My lord, is it to be construed as an exemption? Because where does 23(1) says exemption? 23(1) says prescription. And prescription would include whatever is mentioned in clause 4. If the prescription contained in clause 4 is...
Was NCT conferred any power to grant exemption?
Not if it is not, it
How could grant exemption? Being a delegated authority?
No, my lord, it could not have granted.
It could not have granted.
And therefore, my lord...
the parliament, in its wisdom, thought that it is better to make it absolutely clear. Second proviso is inserted with effect from 2017, requiring every teacher in position on 31st March to possess this qualification.
Please come to the second proviso then. Please read it. Yes. Provided further that every teacher appointed, my lord, would it be appointed in terms of the provisions of the Act? Because the Act does not have any retroactive operation. It cannot go beyond 1/4/2010.
In position as
Or in position as on the 31st.
election means not appointed under this act.
No,
Maybe prior to the
maybe
act.
prior to the Act. My lord, as in or on.
These category we are pointing out. Look at it from the perspective of a child. He needs a good teacher. He needs good quality education. If the teachers are lacking in education, how will they be able to teach the next generation? We have looked at it from this perspective. That's what I'm saying.
And our
must tell you
lordships are bound to. Lordships are bound to look at the holistic picture. We may not be, but I understand, my lord, therefore what your lordships are having in mind. But appointed means appointed in terms of the Act. But can the come after that in position on the 31st of March 2015? Would it take for 2010? We'll consider. Who does not possess, yes, my lord, just one moment, my lord. Who does not possess minimum qualifications as laid down under subsection 1. And therefore, my lord, please read the notification again as part of subsection 1. If your lordships are pleased to that way, then the qualification that we possessed, which is treated as qualification in terms of the clause 4 of the notification dated 23/8/2010, will have to be treated as sufficient for the purpose of proviso 1 and proviso 2.
Thank you.
Lord, this is what we wanted to say.
Yes, Mr. Jha. We believe you are next in seniority.
Sir, Mr.
Mr. Khurshid, you came just now. They have been waiting for some time.
Yes.
Second
I'm 30 seconds, fellow.
one.
Oh, he has been sitting right from the beginning. Sorry, very sorry. We didn't see you. Very well. Otherwise,
I didn't know. Otherwise, I would have given way, my lord.
I would have asked first. Nobody told us.
I would have given. I didn't know.
I've asked my friend to go first. Just as a
My lord, can I just take one more minute, my lord?
You just now said 30 seconds. And now you make it double.
17/10/2017, there is a notification under 23, under section 810, 17/10/2017. It's part of my additional documents.
Very well. What does that?
It amends, my lord, the rules of 2017. There is an explanatory memorandum to this. My lord, lordships could always look into the memorandum for the purpose of sustenance, though it doesn't govern it. Very well. Last line, my lord, in the memorandum says, in providing retrospective effect, interests of no person shall be adversely affected.
Very well.
Please bear that in mind also, my lord, is my refusal.
We see it was interest adversely affected. You want to take a qualification, take it. Prospectively, you can always do.
Mr. Jha, we'll call upon you after Mr. Khurshid.
My lord.
I'm grateful.
Take my turn, man.
Well, it's grateful. Well,
You appear for whom?
two very short points, Mullahs. I mean, item.
No, not the item. You have to
All
make
right,
the
first
party.
for Meghalaya Sarv Shiksha Abhiyan School.
Meghalaya. मैडम इसमें से मेघालय ढूंढिए ना मैडम कौर नहीं इसमें ऊपर नीचे हो गया है मेघालय व्हाट इज
It's called Meghalaya Sarv Shiksha Abhiyan School. Sarv Shiksha Abhiyan Schools Association.
Take it the state.
Yes, but it's state is not
Meghalaya.
Mr. Advocate General is here, Mullahs.
Sarv Shiksha Abhiyan Schools Association. So, sir, your points raised in the review petition are these.
Please, Mullahs.
There was no TET when the petitioners were appointed in the state of Meghalaya. MHRD's notification dated 3rd August 2017 recognized that the existing in-service elementary teachers who lack the minimum professional qualification should be provided a transitional opportunity for upgradation rather than being summarily removed. The judgment under review conflicts both eligibility qualification with quality evaluation. These are the 3 points.
Those are the 3 points. I'm just very briefly going to touch upon 2 issues. One is your lordship's judgment itself, paragraph 169.
Paragraph 169.
Your lordship will just allow me to read paragraph 169. It begins at 168 and then 169. Last 3 lines of 168.
This one. And
Yes.
It begins with only those appointed prior to 3rd September 2001 in accordance with applicable recruitment rules or those covered by specific exemptions such as special BTC or DED courses, etc., were exempted. So there was an exemption. Your Lordships have recognized that exemption. People appointed prior to 3rd September 2001. Thereafter, my lords, your Lordships then say, thus read holistically, Section 23 of the RTE Act and the NCTE notifications together establish that TET as a compulsory qualifying criteria for all teachers appointed on or after 23rd of August 2010. And as a time-bound compliance obligation for those appointed earlier without the requisite qualifications. My only submission is requisite qualifications does not include TET, but if your Lordships have written this judgment, your Lordship knows better what exactly it means. But that's my submission, my Lords, the way I read it, is that it does not mean TET, it means any other qualifications that they don't have, they've been given a compliance period.
Thank you.
Then, my lords, just 3 more lines. The sole object is to ensure uniform teaching standards across institutions, etc. We bow to that. My lords, your Lordships have made this point about how does a notification bypass a statute. But there are 2 statutes involved here. One that I believe has not been taken.
NCTE Act.
The RTE Act.
RTE Act and the NCTE Act.
12A. And
12A is NCTE Act. 12 capital A is of NCTE.
12A capital is NCTE Act. Mullahs, I just want to read out the proviso there. If your Lordships will see 12A. Mullahs, the proviso only says, provided that nothing in this section shall adversely affect the continuation of any person recruited in a pre-primary, primary, upper primary, secondary, or intermediate schools or colleges under any rule, regulation, or order made by the central government, a state government, Educational Amendment Act 2011, etc., solely on the ground of non-fulfillment of such qualifications as may be specified by the council. Next 12A, next proviso. I'll read the next. Provided further that minimum qualifications of a teacher referred to in the first proviso shall be acquired within the period